episode of Writ and Talk, the podcast hosted by Center for Comparative Constitutional Law and Administrative Law at National Law University, Jodhpur. In this podcast, we explore the fascinating world of law and legal scholarship. Today, we have the pleasure of hosting Mr. Shrutanjaya Bhardwaj. Shrutanjaya is a practicing advocate at the Supreme Court, specializing in criminal law, constitutional law, administrative law, and service law. He did his undergraduate law degree from National Law University, Delhi, and his LLM from the University of Michigan Law School in 2019. In the realm of his academic work, Shrutanjaya researches and writes on issues of constitutional interpretation, judicial process, preventive detention, freedom of speech, reservation, and religious freedom. In addition to that, he himself hosts a podcast in a mix of Hindi and English called Law Varta, which simplifies complicated legal issues in comprehensible language. He is also a visiting faculty at National Law University, Delhi, where he teaches an optional seminar course of free speech law. Today, at this podcast, we'll be discussing his article titled Preventive Detention, Habeas Corpus, and Delay at the Apex Court, an Empirical Study, which was published in NUJS Law Review in 2020. In this article, Shrutanjaya undertakes an empirical analysis of the delay in adjudication of habeas corpus petitions in preventive detention cases from the period ranging from 2000 to 2019. He utilizes indicators such as time spent between detention order and final disposal, time spent at Supreme Court level, and time spent in detention. The study suggests that in many cases, habeas corpus is reduced to a meaningless remedy. With this, we welcome our speaker today. Welcome Shrutanjaya. It's a pleasure to host you today. Today we'll be talking about your article Preventive Detention, Habeas Corpus, and Delay at the Apex Court, an Empirical Study, published in NUJS Law Review in 2019.
Thank you. Thank you so much, Prakhar, for having me.
So the very first question that we have for you is to just give us a brief background to your article and perhaps also the inspiration behind it. Why did you decide to undertake this specific area? How were you exposed to this specific field? And what did you find extremely intriguing in it, which you thought was not covered by the available literature when you were writing the article?
So basically this article stemmed from some experiences I had while working with my former bosses, Mr. Gopal Shankar Narayanan and Ms. Haripriya Padmanabhan. There was a bunch of cases I was doing with Gopal sir at the time that were habeas corpus petitions at the Supreme Court. And just observing the general attitude of the court towards these petitions was intriguing. It pushed me to undertake this exercise because I felt that the court was not giving the importance to these petitions. The kind of importance that should be given. And the most important part of that giving of importance is to treat them with some alacrity, to be quick about it. The court was, at least I felt that the court was casually granting adjournments in these matters. And not short adjournments, not, okay, come back after 2 days, we want to hear from the government. It would be a 3-week adjournment or a 4-week adjournment, just like you do in a regular civil appeal, for example. And I felt that can't possibly be right if preventive detention is such a draconian power, as they all say. Not just academics, but Supreme Court judges have said it repeatedly in judgments that, preventive detention is a draconian power, it's an exceptional power, so we should exercise it very sparingly, and the government is then put to very strict tests when it wants to justify preventive detention. So this kind of a practice where adjournments were granted for the asking because the government advocate is not available, he's on legs in another court, so please adjourn it by 4 weeks. All of this was happening, and some of this was in backdrop of the revocation of Article 370 in Jammu and Kashmir. So even, I mean, it had great political significance. So I just thought that, I mean, maybe I'm wrong in sensing this, and maybe what would give me a better picture, a bigger picture of the actual practice of the Supreme Court is an empirical study, because you can easily get misled in one or two instances, but over a period of a few years, 20 years, for example, as this paper studies, that will give you a clear picture of exactly what the attitude of the Supreme Court is. So that was basically my motivation, and that's also what I've said in the paper. I'm doing this because I want to actually test the Supreme Court's sort of alacrity. The Supreme Court says we should have alacrity, but does it actually have that alacrity is what I wanted to study. Yeah.
Right. So you mentioned Article 370. We actually have a very specific question to you with respect to that. But since most of our listeners are also undergraduate students, so before proceeding to that specific question, we would like you to elaborate a bit on preventive detention laws in India in general, and how the Constitution provides for it, how the Constitution will actually provide for a safeguard in those cases, or how is it enabling those?
Yeah. So just to give a background, detention is of two kinds. One is punitive, which is to say that detention is given to you as a punishment for something you've done. The other kind is preventive, which means you haven't done anything, but the government feels that you're about to do something wrong, and therefore the government puts you in custody. Now, by its very nature, because it's based on apprehension, the possibility of misuse is just immense, right? Because the government can at any point get up and say, I think and I have reasonable suspicion that this person is going to commit this offense, and they are going to incite a riot, or in many cases we found that they were theft cases. I've done a follow-up study for the Madras High Court, and many of the cases are theft of electricity, or he's just lurking around in one area and we feel that he's about to steal something. Stuff like that. It's not necessarily always grave offenses like murder or smuggling of foreign exchange, etc. So, because it's a draconian power, the Constitution puts some safeguards. And there's a huge debate in scholarship on whether preventive detention should be allowed at all. Because when the Constituent Assembly was debating this, some people had said, we don't want such a power given to the government. That's a draconian power. Why do you need preventive detention at all? If at all, you wait for them to commit the offense. And if they commit the offense, then you jail them, of course. But don't do it preventively, because then it's just a matter of politics. Whoever hates whoever is going to use that power against them. So the Constitution, I mean, after a compromise, it was decided that we will have a preventive detention power, but we'll subject it to some safeguards. And one of the safeguards is that there has to be a outer limit to how much or for how long you can detain somebody on a preventive basis. And that limit in most parliamentary laws and even state laws, as far as I'm aware, is 1 year. There are a few exceptions, like the Prevention of Black Marketing Act, where it's 6 months. And one of the central laws, which I think the National Security Act, perhaps, where it is 2 years. So there's one law where it's 2 years, one law where it's 6 months, but by and large, most laws provide for 1 year as the outer limit, which means that even if the detention is illegal, right? Suppose the government has done it malafide on bad grounds, then after 1 year, that person has to come out. There's no question of holding him or her in custody after that 1 year. So that makes this alacrity even more important, that in order for the exercise of the court's jurisdiction to be meaningful, it has to be quick, and it has to be so quick that the remedy is not rendered illusory. So in preventive detention law, therefore, the court, that is both constitutional courts, the High Court and the Supreme Court, will have the power to issue a writ called habeas corpus. Habeas corpus, of course, is Latin for produce the body. And what that means is if somebody is in illegal detention, the state will sort of call them. Traditionally, our seniors tell us that the habeas corpus power was exercised in a very, very quick manner, in the sense that today you file a habeas corpus petition and allege that the state has wrongly detained me, and tomorrow the court will direct you to be present in court. So the state will be directed that the detainee has to be produced before me, and all arguments will happen then. So with the detainee present in court before the judge. In some high courts, this actually happens even now, because every high court has its own rules on how habeas corpus petitions will be processed, and some high courts actually follow this. But the Supreme Court, for instance, doesn't follow it. And now what happens is you file a habeas corpus petition, and as usual, the Supreme Court will issue notice, call upon the state to file a reply, give it 2 weeks, 3 weeks to file a reply. Then the state will come, and then the argument is supposed to happen. So that 2 week, 3 week time is sort of taken for granted, that at least that period is going to be spent. And so that's about it. I mean, the role of the court in stepping in at the right time is very important because of the short time for which anyway this person can be in custody. I mean, 1 year is not short at all, but what I mean to say is, if compared against the kind of time that courts usually take with their matters, 1 year is nothing. I mean, no matter gets decided in 1 year in our country. So there's a special need for the courts to sort of step up.
Right. Thank you so much for that brilliant explanation. So before we proceed to the 370 question, we would also like to ask you, as you mentioned that that period is taken for granted by the state. How much do you think, where does the blame actually lie? Is it on the court or on the state? Where is this coming from? Because courts are also delaying it, and the more time you give to the state, they take further extensions in filing with counter affidavits, or the solicitor general, additional solicitor general, or additional advocate generals are not present, or they are handling some other matter which is apparently more important at that particular point of time, right? And attached to this, do you think, considering the amount of petitions which are filed every year, there are already a lot of cases, specifically habeas corpus petitions, and every year more and more of these petitions are filed. Do you think it's humanly possible for only the Supreme Court to take charge of it and dispose these petitions in time, ensuring that these specific fundamental rights are not affected?
Yeah, that's a very important question. That is to say, the question of the backlog that the Supreme Court already has. I think that, it's very unfortunate that the Supreme Court is under that backlog, and humanly, really, it's not possible for the Supreme Court to without compromising on those other cases, to give priority to these cases. But I feel that that should be a non-question, and it's very obvious that habeas corpus matters have to be given that priority at whatever cost. The issue is there are so many human rights matters, other constitutional law matters of grave importance pending before the court, and the court struggles to find time to manage these matters. And this is, of course, a larger discussion on how should we reform the Supreme Court. Should there be a separate court of appeals, and should the Supreme Court only be hearing constitutional law matters? That is, of course, a larger discussion to be had. But I am sort of unwilling to yield to the position that till that happens, the Supreme Court is justified in dilly-dallying these important petitions. And I would sort of say that I really don't care how much pendency you have. There are some matters that deserve to be heard at the top of the list, which are bail matters, habeas corpus matters, sometimes matters of fundamental rights that are urgent in the sense that rights are being violated every day. Those matters have to be heard. You can't push them back. And the Supreme Court has always recognized this, at least in its judgments, once again. So that's as far as the second part of your question is concerned. As far as the first part is concerned, as to who does the blame lie with, my own sense is it lies both with the government and the court. I would always place it more on the court. The reason is that you can legitimately expect the government to be perhaps not legitimately, but you can expect the government to be a political entity and driven by its own politics. And every government is likely to be like that. But the court, especially, is supposed to act as a neutral arbiter. And its allegiance has to lie only to the Constitution. Now, it is not enough for the Supreme Court and the High Court to just say that, yes, our allegiance lies with the Constitution. The problem is that judges hesitate to be strict about it. And what we really need is strict judges in matters like these. Who, the government lawyer may ask for time on any excuse. I am not well. The SG has to argue this matter. The Attorney General has to argue this matter. Attorney General is busy before a constitution bench in another court. These sound like very important excuses because the state has decided that this matter is so important that the Attorney General should argue it. Will the court force a junior lawyer who has appeared in court to argue that matter? And will that, because remember, every time the government is waving that flag of national security or public order, then this man, if you let him out, he's a terrorist, he's this, he's that, and he will kill people, etc., etc. That's what they're saying. So the blame, in that sense, I would always pin more on the court because they're not strict, and these kinds of excuses still fly, and I'm not, particularly excited about this. I would rather that the court would come down heavily on this practice of asking for adjournments in matters like these. And sometimes the court does say that. Sometimes the judges are fair in these matters, and they say that, look, this is a matter of personal liberty. You ask the Attorney General or the Solicitor General or whoever has to appear, additional Solicitor General, whoever, just ask them to come at 2 o'clock today. We'll fix the matter at 2. So that sort of takes care of both concerns. And if that is not possible, then they say, then you send somebody else, but this matter has to be argued today. That's the kind of alacrity we want from our constitutional courts in these matters. And I think that has to be routine. So unless that is achieved, I would continue to blame the judicial institution because they are the ones who are the protectors. The government is, the government is also supposed to be a protector, but we all know how that works.
Right. So you also mentioned about, judges not being strict enough. On that point, we in the last 3 years we have had a Chief Justice like Sharad Arvind Bobde, who said while hearing a petition that you don't come for 32, you go under 226. At the same time, right now you have someone like Justice Chandrachud who has mandated that we'll hear 10 bail matters every day. How much do you think the role of the Chief Justice can be in this specific instance, and what can we expect if the Chief Justice is labelled as quote unquote a liberal Chief Justice?
Yeah, so I personally don't believe in putting these labels to judges because I really feel that judges decide cases individually based on those specific facts. It's a matter of, perhaps you can sort of classify judges broadly as less willing to interfere with government action. In other words, more deferential to the government and less deferential to the government. That's because that's a matter of philosophy, really. and that's not really a matter of politics, so to speak. And I am willing to sort of engage in that kind of a labeling, but otherwise, liberal, conservative, etc., is always inaccurate, and you'll always find judges who are labeled as liberal and who will give you judgments that just don't explain that label, and the other way around, the conservative judges giving quote unquote liberal judgments. As far as the role of the Chief Justice is concerned, it is very important for sure. If the Chief Justice can place bail matters on top of the list every day, then he can certainly also do something similar with habeas corpus matters. And really, there's no distinction between these two. Both are personal liberty issues, and if at all, habeas corpus is more serious because this is preventive. In bail, at least there's an allegation that this person has done something, but in preventive detention, there is not even an allegation. So that is, yes, 100% the Chief Justice can step in and do something about it. But about, for example, you mentioned Justice Bobde and his comment that, we are trying to discourage Article 32 petitions, you go to the High Court, etc. Justice Chandrachud is also like that. In fact, on this principle that Supreme Court will not entertain 32 because High Court is also available, most judges are, on board with this idea. Sometimes, of course, all judges will agree that when it's a matter of urgency and when there is a justifiable cause for the petitioner to not have approached the High Court, then yes, we will hear the petition. But most judges have that philosophy. I don't agree with the philosophy, and I think once again the court is moving away from its original function, which is that it has to protect rights, and it can't. As you know, the Supreme Court has, in its early years, in those constitution bench judgments, many of them, court has repeatedly said that Article 32 uses the word guarantee. So the right to move the Supreme Court is guaranteed, and that's really the only fundamental right that uses that word. And the debates will show you how importantly everybody thought of this right. So to say that, now to say that even though those judgments say we can't send you to high courts, we will anyway send you to high courts because, this is a phrase that judges use. Much water has flown down those judgments. As if judgments can just be watered down. Judgments given by 6 judges, 7. So this I don't agree with, and but just on the point that one judge or the other judge, I think all judges have this philosophy, and it is unfortunate. I think everybody should step up as far as this is concerned.
Correct, actually. I think recently Justice Chandrachud also gave a similar reasoning while dismissing a 32 petition or directing the petitioner to approach to the High Court.
Yeah, no, you see, even in this, the reason that all of them do this is also, there's a justification to that, which is that once again we come to the backlog, because the courts are so, the Supreme Court at least thinks that it is so dying in the burden of SLPs and civil appeals and criminal appeals that it has no time to decide these fundamental rights matters. But I feel that the assumption there is if we send you to the High Court is freer. The High Court will have more time, and therefore the High Court will have less backlog. So the burden will be lesser on the High Court. But I feel that may not always be right. So yeah, sorry, I interrupted you. You were saying.
So it ultimately boils down to the larger question of backlogs and reforms at the Supreme Court and perhaps other constitutional courts as well.
Yeah, that's right.
So we'll proceed to our Article 370 question. So your article basically covers 64 cases from 2000 to 2019. And we all know post-revocation of 370, there have been floodgates of habeas corpus petitions, which again, every day we see some of the other articles saying that these are not being heard. Right? So would you say that this delay, at least from an outsider's perspective, as a student of law, in our limited access to court, we are unable to decipher that, whether this delay in habeas corpus petition is actually more visible today than pre 2019. From an outsider's perspective who doesn't have a similar access to the court as a practicing lawyer might have, citizens generally feel that yes, this is true post 2019. The delays are becoming even more clearer. So would you agree with that, being a practicing advocate yourself?
I'm not sure. I haven't felt that sort of increase, but I think the Jammu Kashmir context is a very specific one, and I would certainly agree that as far as that context is concerned, the performance of our constitutional courts has been very bad. They have not lived up to the expectation, and for a long time, I think the Jammu Kashmir High Court was not even hearing matters. It was it's like COVID hit, and then the High Court has just started adjourning all matters on block. Even habeas corpus matters are not being heard. So it's a situation where you have just been picked up from your house, placed under house arrest or under some other kind of arrest, and just on a preventive sort of an idea. And now you have nowhere to go to challenge this kind of a preventive detention order. So your detention may be right or wrong, makes no difference because there's no remedy. So, yeah, I can't say if overall it has increased or decreased, but yes, in the Jammu Kashmir context, I think there's enough research and writing now to show that in that specific context, we did a very bad job.
So, also considering that the constitutional courts are not living up to the expectation, not just expectation. I would not say expectation, not doing their basic duty. If we can put this in this as simple terms as possible. So, you have talked about providing for monetary compensation, right, as
Yeah.
a relief against illegal preventive detention. The degree of monetary compensation will always remain subjective,
Yeah.
right? In most cases, the court granted the compensation, but the compensation amount is barely anything that can act as a deterrence to the actions of the state, right? So, would it be fair to say that constitutional torts neither act as a punitive measure nor as a deterrent measure, wherein the respondent is the state?
Yeah, I think this is a very important question, and really it boils down to whether the state is bothered about this kind of a relief at all. And therefore, I think it's not just enough to say that the state will pay out of the exchequer. I think at some level, you have to fix responsibility on the officials personally who are concerned. Because, and this will require us to sort of break away from some traditional rules of tort law, which are of vicarious liability. So the state will always be responsible, and that the servant, when he is acting in the course of his duties, is not liable, and the master is liable. So that principle we'll have to break away from when it's a matter of fundamental rights, and maybe we'll have to develop a stricter regime. Perhaps tort law is not even adequate for it. Perhaps we need a statute which lays down that if you arrest somebody or detain somebody illegally, then these are the consequences. We'll start a disciplinary inquiry against you. If the court finds that you did not have reasonable basis to pick up this person, and if the court suggests it, then we will start a disciplinary inquiry against you. I think that's a kind of deterrent that we might ultimately need, or to say that that specific officer has to pay that compensation. It won't be given out of the state's exchequer. So unless that liability is made a bit more personal than just saying that the state has to pay, you're right. I think there will be very little deterrence.
But even if we fix that liability, let's say to the specific officer concerned, uh, don't you think in cases where officers are called from, the CM's office, let's say, or the Home Ministry, when they receive a call from higher officials, they would not be willing to say no to them. So ultimately, it will boil down to an officer who will be perhaps losing his job or having a bad entry or two or disciplinary proceedings in cases where the state could have paid the compensation. So
Yeah. No, you're absolutely right. And there may be cases, especially the politically sensitive ones. In most of the cases, I sense that this won't be a political issue. In most habeas corpus cases, both here and that is both in the Supreme Court and in the other Madras High Court study that I was mentioning, we find that it's about common people for common apprehensions. There are a rare few exceptions where it's political, and yes, in those situations, it will become extremely complicated. How do you fix liability on this officer when he was just or she was just discharging an order? But I guess, these are all details to be sort of figured out in the law that will hopefully come one day. And I suppose that if the officer wants, he or she is at liberty to disclose the name of whoever gave him or her the orders, and then the court can always sort of mold the relief in that manner.
right. We actually have two more questions. The last one is on the Madras study you were mentioning. Before that, one specific thing: h- how much do you think is the role of lower courts and, of course, high courts, including high courts, in this specific area, preventive detention cases, habeas corpus petitions? Is there something lacking from the high courts, which can actually provide for better relief or ensure that personal liberty is not hindered as much as it is hindered at this particular point of time?
Yeah, in fact, if you compare all the high courts generally, I'm currently sort of just starting to work on the other high courts also. It seems that I'm making a broad brush statement, which may be proved later to be wrong by the data. But my sense is that high courts are generally better in performing these roles, and some high courts specifically will decide it on a hear it on a day by day basis and dispose it off very quickly. Some other high courts are not doing very well, but as a general statement, perhaps I would say whatever is true of the Supreme Court is also true of the high courts. They should be careful while granting adjournments, and they should not treat it like other matters. Like for instance, generally, if I tell you about other matters like service matters or writ petitions that I ordinarily do in the Delhi High Court, those will get adjourned by 5 months, 6 months, 4 months. If you ask for a short date, 2 months. It's like that, unless it's like a really pressing issue, in which case the judge will really struggle to find a slot for you in the next 4 weeks or something. So that's the state of the Delhi High Court, because the pendency is so much and the judges are really, burdened. They're very hardworking, and despite that, the disposal rate is not so high because the pendency is huge. And like that, I'm sure there are busy high courts and there are relatively less busy high courts. Whatever it is, I think there has to be some sort of an administrative call to be taken by the Chief Justice, like you mentioned, saying that yes, when such a matter comes before us, it will be given priority, and this is the way in which it will be given priority. Either it goes to a special bench, or if it doesn't go to a special bench, goes before a regular bench, then it goes at the top of the list. And there is a rule that adjournments will not be granted for more than 1 week. You see, there are some procedural sorry there are some procedural aspects to this also. For instance, the Supreme Court has earlier held that no counter affidavit, that is, no reply, should be sought from the state in habeas corpus matters. They say that because anyway, the grounds of detention have already been supplied to the detenue, and the detenue is saying that these grounds are not adequate. That's the ground on which the detenue comes to the court. So there's no need to really get a counter affidavit, because anyway the state is prohibited from raising new grounds at this stage, because they have detained him or her on those specific grounds which have already been furnished to him or her. So this practice of asking the state, issue notice, file a reply in 4 weeks, this can just be dispensed with. And therefore, just by dispensing with this process, perhaps the court can save a lot of time. So these are some procedural things on which the court should not be pedantic. They should be liberal about it and say that, yeah, reply is not needed, or adjournment, if you're seeking, that's fine, come back tomorrow, not after 3 weeks. So, yeah.
Right. I think this is a general hesitancy even in lower courts while hearing bail matters. They are not open to the idea of, granting bail generally. In most cases, uh, this detinue or the accused has to approach to the high court to get bail. Generally, they don't get bails from district courts. Uh, so we'll proceed to the question on your Madras High Court study. So you studied Supreme Court specifically and Madras High Court. Did you find any specific difference, or would you say broadly the issues which are at concern here are similar in the Madras High Court as well as the Supreme Court, or are there any significant differences which which are worth mentioning, and based on which specific reforms or specific solutions might be required in, let's say, one court and not in the other court?
Yeah, no, I would say that they're broadly on the similar lines. And one interesting observation in the Madras High Court study was that many petitions were dismissed as infructuous, because what the government would do is they would detain you today, you will file a habeas corpus, that habeas corpus is adjourned by a month, and overall 2 months from the date of your detention, the state will release you. So by the time the matter comes back before the High Court, the government advocate will stand and say, "My lords, detenue has already been released, so this matter has become infructuous." The court will say, "Right, it has become infructuous." Many cases we found of this nature. So the government nabs you, puts you in custody for 2 months, and then lets you out, and then there's no consequence to that. So that is a shocking pattern we found in many cases. That's one. And it gives you, if anybody does this empirical study, it will give a message to the state that if you want to detain anybody, just detain them and release them after 2 months. And, because the High Court is anyway statistically not doing anything before that. So that is one aspect that came out of that study. The other was the increasing use of the Gundas Act. See, out of all the results that we had studied, all the judgments, most, I would say 90-95%, I forget the exact percentage, but most were cases arising from the Gundas Act. Now, if you're aware, this same act or a similar act exists in 7-8 states, and they're called bootleggers, pirates, gundas, etc., etc. There are some 20 names in that name of the legislation, and that's the name of the legislation. And what it deals with is the state government can declare that you are a gunda, for instance. And after the state government, that declaration is a preventive declaration. We think that you are going to commit some offenses because you have been already accused of some other offenses in the past. So we think that your character is such that you are now a gunda. So now they will sort of, you're a sand offender, you're a pirate, you're a bootlegger, you're a gunda, something like that. They will slap on you and they will put you in custody. And then Madras High Court is allowing these petitions in most cases. Unlike what we found in the Supreme Court, there wasn't such a clear pattern that most petitions are allowed or most petitions are dismissed. Madras High Court, most petitions are allowed. The same kind of a order is passed, saying that the standards under the Gundas Act have not been met. You've just picked somebody up for one single instance of stealing electricity in the past, and you've declared him to be a gunda, and this is not fair, and therefore detention is quashed. and they do it after 6 months or 4 months or 8 months or something like that. So once again, it's meaningless because the total period of illegal detention was 1 year. So what they've achieved is only cut that short by 4 months or so. So yeah, I mean, those two were the glaring findings from that study. One is this aspect of the Gundas Act, and the other is the aspect that I mentioned earlier. Yeah.
So the first issue that you mentioned about the state releasing the detainee
Yeah.
for 2 months. Do you think in those cases perhaps the court should have gone to a claim of monetary compensation, suo motu?
100%. 100. I mean, these are the cases where you really read the order, and I don't know how the case actually played out in court, because what you read in order is just like compromise. The court will never put down its own frustration in the order. Always. I mean, sometimes they do it, but that is really an exceptional case when the judge really loses it. But most often they are restrained, and they will write restrained language in the order. The only question is, how is it that this is happening in so many cases and the court is not sort of coming down heavily on it? Even though, you may think that it's been only 2 months or 3 months since this person was detained. And that's a lot of loss of personal liberty. And once you come out, that stigma stays with you forever. Because everybody, suppose you're from a village, and villages, I mean, level of privacy in India is not, urban areas, people take privacy very seriously. Rural areas, not so much. So you go there, and then everybody knows that this person was in jail for 3 months. And that has long term implications. So, yes, I 100% agree. The court should have granted monetary compensation suo motu. It's just a matter of Article 21, and a strong message has to be sent out in these cases.
We are at the end of the podcast. One last question, because you have written on this specific topic, and I would mention again, most of our listeners are undergraduate students of law. Would you recommend any specific readings on preventive detention, which would include empirical studies or just theoretical understanding, to develop their basic understanding as well?
I would suggest that you generally start off uh, with a good constitutional law commentary that covers both 21 and 22 in detail. I feel that 21 and 22 can't be divorced, and there are many writings on 22 specifically, but I feel that these are so deeply interconnected that you must first read everything that the court has said about 21 and its importance, and then see the contrast with 22 to really appreciate what's going on here, and whether the court really walks the talk in these situations. But as far as one thing that immediately comes to mind is with regard to Madras High Court specifically and the use of the Gundas Act that I mentioned. Akila Ramalingam, who used to be my teacher in law school, she taught me jurisprudence, but now she's practicing in Chennai. She also did study on the Gundas Act specifically and why it is being used so much. And that is really a fascinating study. She discusses how widespread the use is and exactly why it is so problematic. I mean, some fascinating findings. And recently, there was a judgment by the Madras High Court where they granted compensation to the détenu, and it appears that a lot of information from her paper was used, but inadvertently or otherwise, she was not cited in that judgment. But this, I mean, it's a really good paper, and I would suggest that many more people should take up the cause of preventive detention, bail, other matters of rights, and really ask these tough questions to courts. Students have this liberty to do, once they start practicing and once they enter once they tie down to their career, then they'll keep thinking that if I write this, what is the implication to my organization, this, that. While being students, you're much freer, and I feel that if you really want to get into writing, research and writing, etc., This is a great area. There's so much research to be done, so much to examine, so much to put the courts to answer to, that I would really recommend this area. And empirical research is just, I mean, unlimited. You can keep searching and finding more information, and everything you find will be valuable for the community. It will help us move forward, and we all have to keep criticizing the court so that it knows that it knows what its flaws are. Otherwise, the court is too busy. There's no time for self reflection of that sort, of a prolonged sort, that researchers can do.
Thank you so much. I think students will benefit a lot from that. It was a great session. It was lovely to host you, and it was extremely enlightening, at least I can say for myself. Once again, thank you so much for joining us.
Thank you so much, Prakhar, for having me. It was really an enjoyable conversation for me as well.